Hello, my dear friends. I'm Dr. KB Vijayakumar, an advocate practicing in Bangalore. All of us know that for the last 2 weeks, and we do not know for how many weeks more, definitely for the next 2 weeks as well, and we do not know beyond April 14, we have been locked down in our houses to prevent the spreading of coronavirus, which is today taking its toll on the population of each of the countries in the world. I thought I could use this time to help my juniors who may be studying law in various universities across the country. So I felt using my experience as a professor and thereby the teaching experience, as well as my experience in law as an advocate and for a short period as a faculty, I should use my experience to give guidance to those who are about to study law or are studying law in any of the colleges or universities. This effort is in that process. There are a lot of subjects, about between 28 to 36 subjects in a law course, 3-year LL.B course. Some of these subjects may be common for those who are doing 5-year LL.B course as well, maybe BBM LL.B or BA LL.B or BA Honors LL.B, whatever it may be. So I'm going to touch upon those subjects which I feel is the subject for second, fourth, and sixth semesters, for which people will be now writing the exam in June, July, which possibly might be extended as well to a future date, may not be exactly in June, July. So I thought within the next 1 month, let's say by April 30, I should be able to complete the syllabus of the subjects for second semester, fourth semester, and sixth semester, which is about 12 subjects. So today we will begin with international law. We'll have a series of, I'll call this video as a lecture series: International Law 1, International Law 2, International Law 3, depending upon the chapters that it might cover. I should be able to complete each of the subjects in about 10 to 12 lecture series. So if you are following upon these lectures, you should be able to, as if you are sitting in a college, you should be able to get a glimpse of each of the subjects. And at the end of the, maybe by May, end of May or mid-May, I should be able to compile the questions and consolidate them for the last 10 years, 10 to 12 years, and prepare answers for you, which will be helpful for you as the last minute reading of the subject. I'm not going to put that answers on the web or in a video like this, but it will be a soft copy which will be sent to you on request. So now let's start the subject of international law. All of us are familiar with what is international law today, at least vaguely familiar about what is international law. We comment that this is the international law. We discuss about international law. But then, the concept of international law began in 1780, when there was a thinker who thought that international law is a grouping of or a consolidation of rules and regulations that should be adhered to by the states. And here I have to clarify to you, the state does not indicate states like Tamil Nadu, Karnataka, Maharashtra and India. Even in US, it has got more than 50 states. So it does not mean those states. It means state in international law means a country. So we must have a clarity on these issues, that state in international parlance, the jargon of international law, means countries and not individual states within a country. The first and foremost definition, a clarified definition, came from Professor L.L.B. And according to him, which I would say is the first attempt in defining what is international law, he said the law of nations or international law is the name for the body of customary and conventional rules, which is considered legally binding, on the states in the intercourse with each other. Now let us dissect this definition. This is the first definition. All other definitions were a modification of this or a criticism and subsequent modification of this definition. But if you could say that something is the father of international law, a definition which is the father of all definitions, then Oppenheim's definitions will fit the bill. So let us discuss the definition of Oppenheim. He says the law of nations or international law. So international law includes nations. That is what is coming out of this particular wordings. The law of nations or international law. That means the international law means the law of all nations put together. So what is this law? It is the name for a body of customary and conventional rules. Now what is customary? What is conventional? If you look very deeply into this definition, you will see that customary rules in every nation have been should be collated in a way that is acceptable to all nations. There are certain customary rules that are specific to particular states or countries. We are not going into that. But many of the customary rules might be similar in nature in all the nations. Therefore, international law is a body of customary rules and conventional rules. So these two put together, customary and conventionals put together, is a body of rules which form the international law or the law of nations. Now what is the next part? If it is a law, it should be binding on the subjects. In international law, who are the subjects? Different nations, different states. And therefore, law of nations or international law is the name for a body of conventional and customary rules which is considered legally binding. So the law, and therefore it is legally binding, which is considered legally binding on the states in their intercourse with each other. Now what is intercourse with each other? In general parlance, we say it's the relationship. Okay, intercourse means the relationship with each other among the states. Therefore, this definition of international law is very apt. It's very accurate, appropriate to the particular time in 1905. Coming back to the definition, it's very clear. The law of nations is the international law. So the law of nations or international law is the name given to the body of conventional rules and customary rules which are considered legally binding on the states in the matter of intercourse with each other. Excellent definition by its own standards, particular reference to the particular time it was enunciated. Later on, developments took place. World wars happened. United Nations was formed. When the United Nations was formed, there are different multiple wings of the United Nations, like UNHRC, UNICEF, World Health Organization, International Court of Justice, and so forth. Now, what are they in that case? How do they fit in the scheme of Oppenheim's definition of states? This is a point of major criticism of Oppenheim's definition. It says it does not include non-state members. It does not include international organizations and international community. Valid criticism, but then it does not pertain to the particular relevant time. After World War, after the formation of United Nations, we are talking about international community. But before that, it was only states. So different states had to form a general law which will be binding on them to maintain the relationship with each other. That was the intention of Oppenheim. Subsequently, we can criticize. Altogether, it is a criticism which we must agree that as of today, open aims definition falls short of certain happenings that have taken place at a later date. It does not include international communities, it does not include non-state actors, and in fact today they say in international law even the individuals have certain rights and duties, which is not mentioned in open aims definition of international law or the law of nations. And the next is, if we call it about civilized states. Open aim also mentioned instead of states, he says civilized states. What is civilized states? What is uncivilized states? What is this talk about being civilized? Who defines what is civilized? We must remember, in the period of the definition was created, the Western powers felt Christian civilizations are those that are civilized. Christian states or civilized states, and non-Christian states or non-civilized states or uncivilized states. This is a larger thinking during that period. So we cannot say that this will hold good even today, because this very definition of civilized states is not appropriate. So we cannot segregate the states on the basis of being civilized and being uncivilized. State is a state. They are all part of the international community, irrespective of the extent of civilization that they might have with them. That is not the criteria. And therefore, the very valid criticism that the civilized state should be removed and it is not acceptable in the present context. Absolutely true. This is a very valid criticism as well. So later on, the authors of Open Aim's book on international law deleted this civilized states. Civilized. The word civilized was deleted subsequently because they understood that if the definition is to fight the test of time, then they have to evolve depending on the circumstances, and therefore the definition is revised to delete the word civilized and include just states. Now this criticism of Open Aim's definition led to the reformation or modification or reviewing of the Open Aim's definition, and there are several people who came out with their own definitions. Like Fenwick, there is a couple of judgments by Judge Coleridge who said that international law should include all the norms of the member states in the relationship with each other. And in 1948, the International Court of Justice, 1949, the International Court of Justice said those in the service of United Nations are also under the international law as individual performers. This was mentioned, the reparation of injured soldiers of the United Nations force. So somebody who is working for the UN is part of the international community, but as an individual he has got certain rights and responsibilities and duties. And the states also got some responsibilities towards these people who are fighting for the international community. And several international organizations have come into place, which may be private, which may be formed by the states or the United Nations. Like I said earlier, UNHRC, UNICEF, World Health Organization, International Court of Justice, etc., etc. So therefore, the new definitions that came after what Open Aim tried to define, it included international community, it included non-state actors, it included state actors, and included individuals, all to some extent. So the new definition, when you say states, is an embodiment. A state is an embodiment of international organizations. It does not just mean countries like America or China or Russia or India. It is an embodiment. State includes international organizations, state actors, non-state actors, as well as individuals who may be performing international duties. So today, when we talk about a definition of international law, it is that it is a body of conventional rules and regulations binding on the member states in the relationship with each other. Some of the definitions include international community, non-state actors, state actors, and individuals in the definitions. But these are all different definitions. All of them mean the same thing. And if you try to redefine what Oppenheim said, the law of nations or the international law is a body of customary and conventional rules which are considered legally binding on the states, the international community, individual actors, state, non-state actors in the mutual relationship between each other. This could be a definition as of now, which will include all aspects of international law and very apt to the current situation. Now, several nations have reacted after the Oppenheim's definition of international law. We must understand that when we react or when a nation reacts, the purpose is they look at it from their point of view, and therefore whatever is not in accordance to their thinking, line of thinking, then they will oppose it and criticize the definition. This is very natural phenomenon. Now, what did the Soviets say about the international law definition of Oppenheim? They said, no, this is not acceptable. International law is a body of rules and regulations which is enforced by the ruling class, taking into account a struggle and cooperation between the nations and enforced by the nation or the states on their population. Why did they say struggle? Struggle and where does struggle come in international law? If you look at it, the Marxist and Leninist organizations in Russia felt that they are struggling for the survival of the masses, for the survival of the workmen against capitalist tendencies. So they were very particular that the struggle should be included in the definition. Wherever the struggle is not there, then the question of accepting that as international law to their line of thinking is not appropriate. Like I said, each country has its own line of thinking, and if a definition does not fit into their line of thinking, they would object to that. If you look at this definition of the Soviets, if you say that it is struggle and cooperation, the struggle need not be there. It is meant for cooperation. Struggle between country, struggle inside the country, between the people of one country, or the struggle of the nation of one nation may have an impact on its relationship with others. But that as a definition does not feel good. And then the willingness of the ruling class. So if the ruling class does not want to participate in an international law or a particular convention or a customary rule, then it will not accept that. But that is not the nature of international law. International law embodies or includes in itself the common customary rules, common conventional rules in most of the countries. And therefore, telling that my customary rule is not included, so I will not accept this, is not tenable in the international format. So if you are trying to accept the Russian definition, then it has got a lot of inconsistencies which are not applicable today, just like how Oppenheim's definition, though it is more apt and a lot of meaning is added to the word states, is a better definition. Now let's come to Chinese. Chinese said there has got to be a ruling class, there has got to be a state, and there has got to be a relationship between one another. And there has got to be rules and regulations that will guide the nations in their cooperation between each other. This is an expansion of what has been said in Oppenheim's definition. So the Chinese tend to believe that if you segregate the definition into different parts, then it is acceptable to them. And again, they were upset and angry, in fact, about the word civilized states which Oppenheim had mentioned. Because civilized states excluded China because they were not Christian. And it brought in a religious aspect to the theory of international law. So the Chinese objected to this and they said neither the long history nor the long culture of a state is being considered as part of the requirement for international law. If you look at it like that, India has got more than 10,000 years of culture or even more. The history, long history of India is nowhere found in any other nation. Therefore, India also could have got a grievance just like the Chinese. They said we have got a 5,000 years of culture, 5,000 years of customs, 5,000 years of society and nature and rules. So this is not part of what OpenAIM has told, though it is difficult for us to accept this. And they said replace civilized states with just one word, states. Then it will be more acceptable to them. So later definitions came on to include what is civilized, what is uncivilized. So all these arguments were kept aside, and they said states to include international community after the formation of UN, then non-state actors and also individuals who will be part of the international community. So today, when you say international community, then it includes all states, all state actors, all non-state actors, as well as individuals. Now, how do individuals come into play a role in international law, which is called a law of nations? If you want to apply for a visa to visit another country, there's a process. And the process, you have to apply for a visa, giving all the documents that is necessary. The particular country gives you an objection certificate in the form of a visa. They accept, they allow you to enter that country for a particular period of time, for a particular purpose. This is a convention that has been accepted between states. This is a convention, then customary rule that has been accepted by all the states. Today, United Nations addresses nations as member states. They don't say countries. United Nations addresses as member states. We've got about 197 to 200 member states. There are still a couple of countries which are not members of United Nations or which are not recognized by the United Nations as a state or a country. We'll come to that later as to how a state is being recognized by the international community. So my friends, certain judgments in International Court of Justice have given a guidance to what is international law. OpenAIM is the father of definition of international law, and all other future definitions came out of the criticism and modifications in view of the criticism. Many of them were not like a definition, but they were a statement. OpenAIM is the only one which is coming down as a statement. There are people like Charles G. Fenwick who had told that international law is a body of rules and regulations mutually acceptable to the states and binding on each other in the relationship with each other. This I think is the best way to do what you should have thought as international law is. We are coming to the end of this session, and we will go on chapter wise basis, covering the entire aspect of international law as per the syllabus of most of the universities. I am placing focus on Karnataka State Law University syllabus, but most probably it will all be the same, because Bar Council of India is the one who is giving them the permission to run an university, law university, and probably the syllabus is also guided by them. And therefore, I think whatever chapters we discuss might also be common in most of the universities, and I feel and hope that this lecture series will be helpful to those in view of the lockdown, because the colleges are closed and the exams will also be approaching, and I do not know whether there will be curtailing of the number of classroom hours that the colleges might have to comply with as per the directions of the university and the UGC and the Bar Council of India. So I do hope that my little contribution might be throwing some light on the subjects that I intend to cover as a part of a lecture series. So this will be your international law lecture series number 1. Thank you, my friends. Good wishes to you.